Hi, very good morning. This is again a very interesting case. Bombay High Court citation is Make India Impacts versus Union of India and others. So, facts of the case MII, that is Make India Impacts, hereafter I will call it as MII or MI. MI filed a bill of entry. Customs Authority, the goods were dry dates. Customs Authority, after examination, they cleared the goods by issuing an order. The order was issued after release order by Ministry of Agriculture because it is a dry dates and no objection certificate issued by the Food Safety and Standards Authority. So MI paid customs duty. It was given a gate pass. So happily they took the goods out of the customs and by engaging the customs handling agents for delivery to their suppliers. The goods were moving. Suddenly, there was a flurry of phone calls from the customs authorities. They said, wherever you are, bring back the goods. Sir, I have paid the customs duty. I have a gate pass. No, no, no. Bring the goods back. They called the transporters and the agents. So they threatened, if you don't bring the goods, then I will take severe action against you. So, fearing the customs authority, the transporter brought back the goods to the CFS, that is customs area. Then MI submitted a representation to the customs officers that such and such goods were cleared after payment of duty and with the permission. Now this is happening. They submitted a representation, but it was as usual. It received no response. So why this officer called back the goods was, according to the customs authorities, the goods originated from Pakistan and not from Dubai as declared by MI in their bill of entry. So there is a misdeclaration, hence they called back the goods because dry dates from Pakistan is prohibited. It falls under prohibited category. Then MI filed a writ petition before Bombay High Court against the action of customs authority, that is calling back the goods again to the customs area after release of goods and after payment of customs duty. Customs authority said, no, we have powers to call back the goods. They relied on section 47 and 106 of Customs Act. Customs authority, he said, to the Bombay High Court, we did not threaten the transporter or CHA to bring back the goods. We only made a request to bring back the goods. So the MI is lying. We only requested, we did not threaten. That is what they said. Bombay High Court did not believe this. Bombay High Court said, prima facie, it is hard to believe that the goods were brought back on the request of the customs authority, request within courts. The issue before the court was whether the action of customs authority requesting, again request within courts, the transporter to bring back the goods cleared after payment of customs duty is lawful or not. That was the issue. Bombay High Court said customs authority is a government official conferred with statutory powers and it comes also with duties, corresponding duties. The power must be exercised in accordance with law. Even if it is assumed that the authority was not acting out of any ulterior motives or for any extraneous consideration, as contended by MI. MI said, no, no, this authority threatened us because he had something in mind. He wanted something. That is why he threatened. So, court says, even if it is assumed that the authority was not acting out of ulterior motive or any extraneous consideration, the ends cannot always justify the means. The court said, while exercising writ jurisdiction, court is concerned with the decision making process rather than the ultimate decision. Any alleged absence of malafide is no substitute for acting contrary to the law or legal procedures. Section 47 actually talks about clearance of goods after proper verification. After clearance of goods, suppose if it is found to be fraudulent for some reason, only a show cause notice can be issued. But that was not done in this case. Instead, the customs authority, without making any order or recording any reasons in the file, called the CHA and the transporter to bring back the goods which were cleared from customs. The authority exercised power which did not authorize him to act in that manner. Bombay High Court said that divesting of such goods from the custody of the petitioner, that is MI, or his agent, was not shown to be backed by any law or lawful procedures. There was no minimum compliance with the principles of natural justice and fair play. It is well settled. The, any action which visits a party with civil consequences must be preceded by at least minimum compliance with the principles of natural justice and fair play. Further, such action must be authorized by law and must not be merely backed by the color of office. In this case, they are DRIs, revenue intelligence. They have enormous powers. So they use their office and ask them to bring back the goods. So court says it must not be merely backed by the color of office. It must be backed by law. Customs authority relied on section 106 which deals with smuggling. I don't want to get into full details, but apparently it seems that section 106 deals with the goods which are smuggled. The submission was that reason to believe the submission of the customs authority was that reason to believe must be presumed, whether any writing or noting was made or not. That is the submission. Because they said in a money laundering act and other acts, it will be always presumed. Similarly, you have to presume the reason. We need not have to even put it in writing. That was the submission by the customs authority. Bombay High Court rejected this submission by stating that such a blanket proposition cannot be accepted as justification for the exercise of statutory powers by a statutory authority given the circumstances in this case. Ultimately, the rule of law requires that statutory authorities act in accordance with law and within the bounds placed upon the exercise of their power by law. Bombay High Court said that divesting was not shown to be backed by any law or legal procedures. Divesting of the goods. They asked them to bring back the goods. So it says it was not shown to be backed by any law or legal procedures. There was no minimum compliance with natural justice. Statutory orders made by one of the customs official, because the goods were cleared by one of the customs official after examining the bill of entry and verifying the country of origin, etc., etc. He cleared the goods and permitted them to pay the customs duty and clear the goods. So one officer cleared the goods. The other officer entirely ignored that order. Further, Bombay High Court noted after 2 weeks of the divestment, that is bringing back the goods to the customs, MI cleared identical consignment from the same exporters and the same ports without any objection by the customs authority. So immediately customs said, see, you must see our bona fides. Whenever the goods are correct, we never did any this thing. Only when we suspected, only when we received intelligence by uh, intelligence that the goods were from a prohibited country, that is Pakistan, then only we called back the goods. This submission of customs was not accepted by the Bombay High Court. Bombay High Court said there are detailed rules governing the verification of the country of origin for imported goods. None of the provisions of these rules appear to have been followed by the customs authority. There is a procedure for overcoming a clearance order made under section 47. That is, they could have instituted a revision They could have adopted such other lawful procedures given under the law, which would include at least a show cause notice, opportunity of hearing, etc. None of these legal provisions was resorted to by the customs authority. Bombay High Court said the action of the customs authority, at least prima facie, did not appear to have any backing of the law. Such action has not been justified by the customs authorities by referring to any law or legal provision. The legal provision, that is, they said 106 permits us to do that, referred to, cannot justify the action. Even outside the written law, assuming there is a outside you are acting, it is well settled. Principles of natural justice and fairness must be followed before any party is subjected to serious civil consequences. Even such principles do not appear to have been followed, even minimally, in the present case. Bombay High Court said once the goods were cleared from customs, some semblance of the observance of legal procedure, not to mention compliance with natural justice, was essential before the goods were brought back into the CFS customs area based on the flurry of phone calls by the customs authority requesting the customs brokers and transporters to bring back such goods. A request was made by MI. At this point in time, in the writ petition, the MI requested to Bombay High Court to release the goods by imposing a redemption fine or by directing MI to furnish BG, because they said it is a dry date, so it will perishable goods. So please don't detain the goods. Kindly release the goods. We are ready to pay redemption fine, or we are ready to furnish bank guarantee. Please release the goods. That was the submission made by MI. This was also not accepted by the court. Bombay High Court said customs authorities are not obliged to release prohibited goods because goods from Pakistan is prohibited. To release prohibited goods upon payment of redemption fine. Discretion was granted to customs authority to release or not release the goods. This discretion must be exercised judicially and not arbitrarily. Bombay High Court said that this case concerns only dry dates and not narcotics. Whatever it is a eatable goods only, not a narcotic. So the only concern is origin of the country, that is Pakistan. The customs authorities are certainly entitled to enforce this prohibition, but they cannot take the law into their hands or unreasonably delay the proceedings so that the goods will perish. So, after getting the order, you don't deal with that. Goods will automatically perish. The contention of customs was that even if the goods perish, let us assume that it perishes, then MI can file a suit and claim damages against the customs. Uh, they have a remedy. Bombay High Court did not accept this contention also. Bombay High Court repeatedly asked the customs authorities to tell a time frame within which a show cause notice can be issued by the customs authority. The reply given by the customs was, no, 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 we cannot tell you any time frame because these matters take time. That was the reply by the customs authority to the court. Then court director customs to issue show cause notice within 4 weeks and dispose the show cause notice within 6 weeks after providing opportunity of hearing. If not done, customs was directed to release the goods after imposing redemption fine or after securing BG. So my comments, the saying is, however high you are, the law is above you. That is the saying. But I will make a small correction here. However high the law is, the customs and GST authorities are always above the law. That is point number one. Point number two. In one of my earlier videos, the same customs, I when I was an officer of a multinational company, when I was how the customs authority behaved with me in relation to a related party transaction, I have captured there. So I just want to say about this also. The same attitude I have seen in GST authorities also. outside the law. In this case, in the third point, in this case, it may be really true. I don't suspect the officers. See, you cannot say all are bad or all are good. So man is man. Not all are good, not all are bad, but mostly 90% is bad, 10% is good. Tax officers. Uh, it may be really true. Intelligence might have been received by the authority. But how can they order to bring back the goods which were cleared after proper verification and after payment of customs duty? That too by request, loving request. They called them, please bring back the goods, and they brought the goods back. So that is unbelievable. And finally, the fourth point. In Tamil, there is a word called custom. Custom means difficult. So I would end the this video by saying, handling customs authorities are romba custom. Romba means very difficult. Custom means difficult. So romba custom, very difficult. Thank you very much. Uh, Bye.